Please be seated. The sitting is open. The court meets this morning to hear the second round of oral observations of the Gambia on its request for the indication of provisional measures. I see that Mr. Reichler is already at the lectern. I will give him the floor. You have the floor.
Thank you, Mr. President. Good morning, Mr. President. Good morning, members of the court. Myanmar made two arguments about genocidal intent. First, they denied that they acted with genocidal intent in their treatment of the Rohingya. Second, they argued that even if genocidal intent can be inferred from their conduct, it is not the only plausible inference that can be drawn. I will respond to the first argument. Professor Sands will answer the second. What is most striking, Mr. President, is what Myanmar has not denied. So I will begin there. Myanmar has not denied that the UN fact-finding mission reached this conclusion. There is no reasonable conclusion to draw other than the inference of genocidal intent from the state's pattern of conduct. Nor has Myanmar denied that the fact-finding mission reached this conclusion based on 7 specific indicators which it found to be, quote, indicators of genocidal intent in the international case law. Nor has Myanmar challenged the propriety of the fact-finding mission's use of these 7 indicators, or any one of them, for inferring genocidal intent. Professor Akhavan identified them on Tuesday. I call them to your attention today only for the purpose of considering what Myanmar said or failed to say about them yesterday. This is the first indicator of genocidal intent. First, the Tatmadaws' extreme brutality during its attacks on the Rohingya. Professor Akhavan and Mr. Lowenstein gave you many heart-rending examples of this from the reports of the UN fact-finding mission. Myanmar did not deny any of it. In fact, its agent admitted that, quote, it cannot be ruled out that disproportionate force was used by members of the defense services. Second, the organized nature of the Tatmadaws' destruction. Mr. Lowenstein showed you how the Tatmadaw employed the same brutal tactics in each Rohingya village, in clearance operations that were planned and ordered by senior military staff. Myanmar did not deny this. Nor did they deny that 392 Rohingya villages were systematically destroyed, either totally or partially, during these operations. Third, the enormity and nature of the sexual violence perpetrated against women and girls during the clearance operations. We heard nothing about sexual violence from Myanmar yesterday. Not a single word about it, not from the agent, not from any of their counsel. Because it is undeniable and unspeakable, they chose to ignore it completely. I can't really blame them. I would hate to be the one having to defend it. Fourth, the insulting, derogatory, racist, and exclusionary utterance of Myanmar officials and others prior, during, and after the clearance operations. Myanmar did not deny any of this either, nor could it. The agent even underscored its significance. Quote, "Hate narratives are not simply confined to hate speech. Language that contributes to extreme polarization also amounts to hate narratives." And here is such a narrative. From the Facebook page of Senior General Min Aung Hlaing, the Commander-in-Chief of the Tatmadaw, before Facebook took his page down. Posted at the height of the 2017 clearance operations, it described, quote, "the Bengali problem as an as yet, quote, unfinished job that the government in office is taking great care in solving." He added, "We openly declare that absolutely our country has no Rohingya race." Returning to the 7 indicators of genocidal intent. Fifth, the existence of discriminatory plans and policies, such as the citizenship law and the national verification card process, as well as the government's efforts to clear, raise, confiscate, and build on land in a manner that sought to change the demographic and ethnic composition of Rakhine State. Again, no denial by Myanmar. How could it? Myanmar's laws and policies overtly and expressly discriminate against the Rohingya. All the agent could say was that birth certificates would now be issued regardless of religious background, but not citizenship, and nothing about the confiscation of Rohingya lands. 6, the government's tolerance for public rhetoric of hatred and contempt for the Rohingya. Myanmar did not deny this either. And 7th, the state's failure to investigate and prosecute gross violations of international human rights law and serious violations of international humanitarian law. This is the only indicator of genocidal intent, the only one of the 7 that Myanmar has disputed. The agent herself asked, quote, "Can there be genocidal intent on the part of a state that actively investigates, prosecutes, and punishes soldiers and officers who are accused of wrongdoing?" Mr. President, we could not help but ask ourselves, what state is she talking about? It is certainly not Myanmar. The agent herself made this perfectly clear. Quote, "Under its 2008 constitution, Myanmar has a military justice system. Criminal cases against soldiers or officers for possible war crimes committed in Rakhine must be investigated and prosecuted by that system." To her credit, the agent acknowledged the difficulties with such a system. Quote, "It is never easy for armed forces to recognize self-interest in accountability for their members and to implement a will to accountability through actual investigations and prosecutions." It certainly isn't easy in Myanmar. How can anyone possibly expect the Tatmadaw to hold itself accountable for genocidal acts against the Rohingya when 6 of its top generals, including the Commander-in-Chief, Senior General Min Aung Hlaing, have all been accused of genocide by the UN fact-finding mission and recommended for criminal prosecution? In addition to Senior General Min Aung Hlaing, these include the Deputy Commander-in-Chief, Vice Senior General So Win, and the commanders of the 2 light infantry divisions, the 33rd and the 99th, which were primarily responsible for carrying out the clearance operations against the Rohingya, Brigadier General Ong Ong and Brigadier General Than U. 2 days ago, on 10 December, International Human Rights Day, the United States government imposed sanctions on all of them. The official announcement by the U.S. Department of the Treasury, at tab 25 of your folders, described the crimes of which they are accused. When you read this document, you will see, under the name of each of these generals, that these are the same genocidal acts that the UN fact-finding mission reported and that Professor Akhavan and Mr. Lowenstein described on Tuesday. Of particular interest, in light of the agent's comment on accountability, the United States government warned that, quote, such abuses and the continuing impunity must stop. Burma's military must address the climate of impunity and cease abuses and violations of universally accepted human rights. It should come as no surprise, then, that the Tatmadaw has not been willing to investigate, prosecute, or punish its own members for crimes against the Rohingya. There has been just one prosecution, which was initiated only in response to an international outcry and ended with full pardons issued to the perpetrators. I beg the court's forgiveness for displaying these photographs at tab 26, which are difficult to look at, and some in the courtroom might wish to look away. But the extreme brutality of the Tatmadaw toward the Rohingya is part of the evidence of genocidal intent. Even Myanmar has not denied this. This is a photo obtained by Reuters reporters of 10 Rohingya men in Tatmadaw custody with their wrists tied behind their backs at In Din in Rakhine State. This is a photo obtained by the same reporters immediately after they were executed at point-blank range. After the photos were published worldwide, the Tatmadaw made an arrest, not of the soldiers who committed these brutal murders, but of the Reuters reporters. They were tried by a military court, convicted of violating the Official Secrets Act, and sentenced to 7 years of imprisonment. The international community came down hard on Myanmar for this, and the Tatmadaw eventually put the killers on trial and sentenced them, but gave them full military pardons after serving only 7 months. The message was not that soldiers would be held accountable for crimes against the Rohingya, but exactly the opposite. Even the agent admitted, quote, Many of us in Myanmar were unhappy with the pardons. Unhappy, perhaps, but absolutely unable or unwilling to do anything about it. The agent and Professor Okoa mentioned one other prosecution by the Tatmadaw. What they neglected to tell you was that the victims were not Rohingyas and the crime was not committed in Rakhine State. It had nothing to do with the Rohingya. We were also told about the initiation of a new court-martial proceeding on 25 November 2019, 2 weeks after the Gambia's application was filed and 2 weeks before these hearings began. Could there be any connection? Reference was made yesterday to an international commission of inquiry created by Myanmar to investigate events in Rakhine State. We were told by the agent that it might lead to new prosecutions, but that is not how the chair of the commission sees it. She stated very clearly that, quote, there will be no blaming of anybody, no finger pointing of anybody because we don't achieve anything by that procedure. On Tuesday, we called your attention to the observations of the UN Special Rapporteur for Human Rights in Myanmar. She wrote, as you will recall, quote, those responsible for these violations enjoy impunity, which perpetuates the devastating cycle of abuse, and that Myanmar is, quote, incapable of delivering accountability. Now perhaps you can better appreciate how well-founded these observations are. Mr. President, Myanmar's agent told you that Myanmar is, quote, committed to the voluntary, safe, and dignified repatriation of displaced persons from Rakhine under the framework agreement reached between Bangladesh and Myanmar. She then asked another rhetorical question, quote, how can there be an ongoing genocide or genocidal intent when these concrete steps are being taken in Rakhine? Professor Okoa spent much of her time extolling the virtues of this supposedly wonderful repatriation program. In fact, it is a complete fraud. Even Professor Okoa admitted, quote, it is true that few displaced persons have returned. The UN fact-finding mission explained why in its September 2018 report. While the Myanmar government has, in principle, committed to Rohingya repatriation, nothing thus far indicates this will be in a manner ensuring respect for human rights, essential for a safe, dignified, and sustainable return. The fact-finding report continues. On the contrary, Myanmar is making active efforts to prevent this return through the consolidation of the destruction of Rohingya villages, through appropriation of vacated land and terrain clearance, erasing every trace of the Rohingya communities, and the construction on this land of houses for other ethnic groups. This deplorable situation did not change as of the fact-finding mission's September 2019 report. Conditions in Myanmar are unsafe, unsustainable, and impossible for approximately 1 million displaced Rohingya to return to their homes and lands. The fact-finding report continues. The government is able, but unwilling, to change conditions in Rakhine State to ensure the Rohingya are able to enjoy all of their human rights. This is perhaps the strongest indication of why Rohingya justifiably insist that they are not prepared to return at this time. Professor Okoa claimed that Myanmar's lack of genocidal intent is proven by UNHCR's collaboration with the government on repatriation of displaced Rohingya. But she failed to quote from any of UNHCR's actual reports, including this one to the Security Council. Conditions are not yet conducive to the voluntary repatriation of Rohingya refugees. The causes of their flight have not been addressed, and we have yet to see substantive progress on addressing the exclusion and denial of rights that has deepened over the last decades, rooted in their lack of citizenship. Nor did she quote from this UNHCR report. UNHCR and UNDP, as was mentioned, have committed to helping Myanmar create conditions inside Rakhine State that would be conducive to the voluntary and sustainable return of refugees, meaning freedom of movement and a pathway to citizenship for those who remain. These conditions were stipulated in the MOU, but are not yet in place. We are still waiting for access to carry out our work. These conditions are still not in place, Mr. President. Senior Myanmar government and military officials refuse even to use the word Rohingya in order to preserve their racist myth that no such group exists. The court will have noted that the agent, as is her custom, refused to refer to the Muslims of Rakhine State as Rohingya. She uttered the word only in reciting the full formal name of the ARSA insurgent group. Myanmar's rejection of the Rohingya and its failure to carry out its commitments to UNHCR and UNDP demonstrate that it has no intention of allowing the displaced Rohingya to return. This is the view of Bangladesh, which Professor Okoa mistakenly depicted as having a favorable view of Myanmar's commitment to repatriation. On 9 June 2019, the Ministry of Foreign Affairs issued the following statement. The government of Myanmar failed to restore normalcy in northern Rakhine and make any visible progress in creating an environment conducive for return, which is an essential precondition for the commencement of repatriation. Other than making hollow promises, Myanmar has so far made hardly any progress in fulfilling its obligations. Professor Okoa misconstrues the willingness of Bangladesh and other states to promote repatriation of the Rohingya as endorsement of Myanmar's actions. China and Japan are to be commended for contributing to infrastructure and transportation to facilitate repatriation. And India, too, is to be applauded for its encouragement of repatriation. But it is up to Myanmar to create the conditions conducive for voluntary return, as UNHCR has repeatedly reminded it, and it has stubbornly refused to do so, as both UNHCR and the UN fact-finding mission have reported. And as a result, as even Myanmar's council admits, no significant repatriation has occurred. Reference was made to a commission headed by former Secretary General Kofi Annan, which presented a report in August 2017. It is of no assistance to Myanmar in these proceedings because, as the UN fact-finding mission observed, the Annan Commission's mandate, quote, was focused on proposing concrete measures for improving the welfare of all people in Rakhine State. It was not mandated to investigate specific cases of alleged human rights violations, and it did not make any such investigation or finding. Mr. President, Myanmar has told us that its clearance operations were not aimed at destroying the Rohingya. but were actually intended, to quote the agent, quote, to clear an area of insurgents or terrorists by deliberately killing Rohingya children, slaughtered mercilessly by the Tatmadaw in these clearance operations. Many were infants, beaten to death, or torn from their mother's arms and thrown into a river to drown. How many of them were terrorists? By raping and gang raping and savagely mutilating women and girls? Is that indicative of fighting terrorism or of committing genocide against a hated group? By burning to the ground hundreds of villages and thousands of homes with entire families forced to remain inside? Where is the evidence that the Tatmadaw's clearance operations were primarily directed at insurgents or terrorists and not at the Rohingya population? There is very little. We have been told that the trigger for the 2017 clearance operation was an attack by ARSA on 25 August of that year. But contemporaneous reporting from Myanmar shows that the Tatmadaw deployed its notorious light infantry divisions to northern Rakhine State 2 weeks earlier, as of 11 August, as reflected in this article in the Irrawaddy at tab 27, complete with photograph of arriving troops and quotes from senior military officers. The evidence is more consistent with Senior General Min Aung Hlaing's Facebook post that the troops were deployed because it was time to solve the Bengali problem once and for all. Mr. President, we do not contend that there were no insurgents or that Myanmar did not have the right to take military action against them. But we do contend that armed conflict can never be an excuse for genocide. As the UN fact-finding mission observed, regarding the Tatmadaw's conduct of these clearance operations, quote, there was not the least effort on their part to make any distinction between ARSA fighters and civilians, or to specifically target a military objective, or identify and repel an immediate threat. Everyone was a target, and no one was spared. Mothers, infants, pregnant women, the old and infirmed, all fell victim to this ruthless campaign. Professor Shabas helpfully confirmed that reports of fact-finding missions like this one may contain valuable information. However, he criticized the UN mission's conclusions in its September 2019 report that evidence of Myanmar's genocidal intentions had strengthened over the past year, on the ground that the mission did not mention how or on what basis it reached that conclusion. He must have skipped over all the relevant paragraphs. Paragraph 9, for example, summarizes the evidence the mission considered in reaching its conclusion. It includes, quote, the government's hostile policies toward the Rohingya, including its continued denial of citizenship and ethnic identity, the living conditions to which it subjects them, its failure to reform laws that subjugate the Rohingya people, the continuation of hate speech directed at the Rohingya, its prior commission of genocide, and its disregard for accountability in relation to the clearance operations of 2016 and 2017. Much of the report consists of extensive details supporting all of these findings. Professor Shabas was also mistaken in asserting that there are no mass graves. To be sure, Myanmar has not made it easy to find them. It has systematically denied independent fact-finders and human rights organizations, as well as journalists, access to areas of Rakhine State where its clearance operations were carried out. Nevertheless, the Associated Press located at least 5 mass graves of Rohingyas. The report is located at tab 28 of your judges' folders. Professor Okowa told you that the requirement of urgency is not met and that provisional measures should be denied because, allegedly, the decision to sue Myanmar was made in March 2019 and the application was not filed until November. She asked, somewhat sarcastically, it appeared, quote, was there something that happened in the interim that gave urgency to the request for provisional measures? The answer is yes. The submission of the UN fact-finding mission's report in September 2019, which concluded that evidence of Myanmar's genocidal intent had strengthened in the past year and that, quote, there is a serious risk that genocidal actions may occur or recur. That prompted the Gambia to proceed as quickly as possible to retain counsel and file the application. I would also refer Professor Okowa to her colleague, Professor Zimmerman, who was listed as counsel to Myanmar in these proceedings. In his commentary on Article 41 of the court statute, he states, quote, under the aspect of urgency, it is not relevant whether the situation complained of had already existed for a considerable time when the request was filed. For what is important is only the imminence of action prejudicial to the rights at stake. Mr. President, we demonstrated on Tuesday that there is an urgent need for provisional measures to prevent irreparable harm to the rights of the Gambia that are at issue in this case, and that the case for provisional measures here is among the most compelling that have ever been presented to the court. Nothing Myanmar said yesterday contradicts this. The fact-finding mission's conclusion that the only reasonable inference to be drawn from Myanmar's pattern of conduct is genocidal intent still stands. Indeed, as we have seen this morning, Myanmar either admits or fails to deny what the extensive evidence we submitted makes perfectly clear. There is an urgent need for provisional measures to prevent irreparable harm to the Gambia's rights as a state party to the Genocide Convention. Mr. President, members of the court, this concludes my presentation. I thank you again for your kind courtesy and patient attention, and I ask that you call my colleague, Professor Darjan, to the podium.
I thank Mr. Reichler for his statement. I'll now give the floor to Professor Pierre Darjan. You have the floor.
Merci, Monsieur le Président. Monsieur le Président, Madame la Vice-présidente, Mesdames et Messieurs les juges, il me revient de répondre aux arguments qui vous ont été présentés hier par Maître Staker autour du thème de votre compétence prima facie, National Organization, et que la Gambie a saisi la Cour non pas en tant qu'État partie à la Convention, mais en sa qualité de président du comité ministériel ad hoc de l'OCI, c'est-à-dire en tant qu'organe de cette organisation internationale. Maître Staker en a déduit que votre compétence rationnée personnelle,
that is to say, as a body of this international organization, Mr. Staker inferred that your ratione personae jurisdiction was lacking, and therefore thinking otherwise would be tantamount to circumventing the requirements of Article 34 of the statute. This proposal disregarded reality. It is indeed Gambia that suggested that the OIC adopt the resolution 59/45 of May 2018. It is not the OIC that mandated Gambia. It is Gambia that sought within the OIC the support of its member states, and that is assuredly its right. Similarly, nothing prevents Gambia to receive financial support from other states. Furthermore, Mr. Staker was in a situation of legal contradiction contradiction because he said both that Gambia would have acted as a body of the OIC and as a proxy. Of course, in law, it could be a situation of either or, but in reality, it was in fact neither nor. The fact that the presidency of the ad hoc ministerial committee came back to Gambia due to its initiative does not transform Gambia into a body or agent of the OIC, and in fact it is not in this capacity that Gambia called upon the court. In fact, Gambia submitted its application instituting proceedings, and this legal act is undeniably attributed to Gambia as a member state of the United Nations and therefore bound by the statute of the court and having access to it. The agent of the Gambia who signed the application is the Minister of Justice. He is the body of the country and was not at the disposal of the OIC and acted under or did not act under the official control of this organization or as a proxy. No document having been submitted supports that the OIC gave mandates to one of its members in the present case. The member states of the OIC, in fact, only encouraged Gambia to act before the court. There is no, therefore, proof of the Article 34 being circumvented, it's just that the 56 other states encouraged Gambia, and there is no proof of circumventing the article, even if they all belong to the same organization. And in this respect, it is irrelevant that 13 of the 57 member states of the OIC were not bound by the convention and its Article 9. The proceedings pertaining to the application of 11th November are between Gambia and Myanmar. And the dispute, therefore, is indeed a dispute between Gambia and Myanmar and not between OIC and Myanmar. Mr. Staker recycled his ratione personae argument when the examination of the ratione material jurisdiction of the court was examined. But for the same reasons, it must be rejected. Mr. Staker claimed that no dispute existed between the parties before the 11th of November 2019. That is the date the application was submitted. But my colleague, Mr. Suleiman, clearly explained that a dispute did exist before the session of the court. Mr. Staker first argues that the OIC resolutions are irrelevant to establish the prior existence of a dispute because Myanmar is not a member, and that these resolutions do not contain any positive affirmation according to which Myanmar would have violated the convention, whereas based on the Marshall Islands case, he questioned the significance of Gambia's positive vote. The fact that Myanmar is not a member of the OIC is irrelevant because these resolutions were brought to its knowledge and Myanmar did not refute that because it reacted to them. Furthermore, these resolutions explicitly target Myanmar and the situation of the Rohingyas, whilst they refer to the need to prevent genocide. Such is notably the case of the May 2018 resolution that created the Ad Hoc Ministerial Committee. Resolution 4/46 of March 2019, which was not annexed to the file that Myanmar submitted to you yesterday, but was covered in the application and was annexed to the observations of Gambia, calls on Myanmar to honor its obligations, and I quote, under international law and human rights covenants, and to take all necessary measures to immediately halt all vestiges and manifestations of genocide against Rohingya Muslims, unquote. I doubt that one can be any clearer in diplomatic language. why ask for the fulfillment of obligations if they hadn't been violated at all to begin with? As to the vote of Gambia to support the resolutions, may I recall that they did not contain a host of different proposals, but they were based on a single theme, and hence the meaning of these voting patterns is crystal clear. Mr. Seko also said that the fact-finding missions reports could serve as a basis to identify a prior dispute between Gambia and Myanmar. Gambia is not an author of these reports, but it is indisputable that welcoming the fact that Gambia wanted to refer the current dispute to your jurisdiction means that the UN report had necessarily notified Myanmar, particularly since the respondent rejected the report. So Myanmar couldn't possibly have not been aware of the dispute. Mr. Staker considered that the declaration of Gambia at the UN General Assembly was irrelevant because the Gambian Vice President failed to specifically mention the Genocide Convention. The Gambian declaration dates back to the 26th of September, that is to say, 10 days after the fact-finding mission's report, referring explicitly to the Genocide Convention and welcoming the intention of Gambia to bring the dispute before the court, and 3 days before it was categorically rejected by Myanmar. Does Mr. Staker seriously argue that Myanmar could have legitimately thought that the object of the dispute that Gambia was bringing before the court could have changed completely in a matter of just a few days? As to the Gambian note verbal of the 11th of October 2019, Mr. Staker made several objections but did not deny the fact that Myanmar had received it. According to Mr. Staker, the note verbal did not require any answer because it did not specify any particular fact supporting the charges that it contained.
Mr. Staker is clearly mistaking the requirements of Article 38 of the rules pertaining to content of an application, with the simple need to point out before the application that the parties are in disagreement in regard to certain international obligations. Furthermore, inasmuch as, contrary to other compromissory clauses, Article 9 of the Convention does not subject the jurisdiction of the court to the existence of pre-existing obligations, the requirements pointed out by Mr. Staker are simply without basis. The court may do well to contrast the submission by Mr. Baker, whereby Myanmar doubtlessly did respond to the note verbal by Gambia if it had been more elaborate, or it would have responded rather, with the attitude of Myanmar when the report was submitted, that is to say, the report of the fact-finding mission. This simple fact allows the court to reject the assertion whereby that the month went by between the note verbal and the application, and that this allowed Myanmar to take a position. The respondent state had a month, actually only 13 days, to reject a sentence in a report containing 190 pages on 16 September. Mr. Staker maybe could enlighten the court as to the proper amount of time that, in his view, a state accused of genocide would have to wait before responding to such an accusation that has already several times been rejected. Mr. Staker has also questioned the reason whereby the note verbal was sent a week after Gambia procured the services of legal counsel and not before, and he reaches the conclusion that the note verbal was a mere legal formality. If by legal formality Mr. Staker is referring to the action confirming the existence of a dispute, then he has correctly identified the nature of the note verbal of 11 October. Unless he considers that Myanmar's silence is tantamount to consenting of responsibility, he is simply confirming the existence of a dispute between the parties under the convention and before being presented to the court. Well, before he contested the plausibility of rights under litigation, which Gambia requests protection for, Myanmar expected this more than a month before. Mr. President, Whereas Mr. Shabazz contested the plausibility of the claims, which is distinct from a subject from the one I am addressing. My colleague will be addressing that. He addressed the plausibility of claims. Mr. Staker, however, did not contest the plausibility of the rights which Gambia is requesting the protection for. He nevertheless considered that instead of maybe there being wrongdoing in these actions, Gambia may not have standing in this procedure. Mr. Staker did not contest that Gambia had the right to invoke Myanmar's responsibility as a state other than a wronged party under Article 48 and the Articles on International Responsibilities of States. However, he did consider that the invoking of such responsibility could not be done only under international relations, but not before a judge. He also said that the Belgium-Senegal case should be distinguished from this case because in that case, Belgium would have been a state that was subject of wrongdoing, but he separated this from Actio Populares. On this last point, Professor Sands will be responding to Mr. Staker, and I will thus limit myself to several observations on the alleged lack of standing. In referring to the judgment Belgium vs. Senegal, Mr. Baker did not explain the reason whereby the court first did not consider it necessary to identify whether Belgium had been affected, and secondly, where the court affirmed in general terms that vis-à-vis erga omnes partes obligations, the requirement of a specific interest would have as a consequence that no state would, in most cases, be able to present a claim against the state that had actually committed a wrongful act. As to the distinction between claiming responsibility in the context of international relations or before the court, this distinction appears to be particularly obscure and unjustified. Invoking responsibility before a judge in diplomatic relations is always intended to assert a breach of law. The distinction suggested by Mr. Staker does not appear in the work of the International Law Commission, and it is also contradicted by the Institute for International Law when a jurisdictional link appears between the parties. Mr. Staker has also stated that the application for provisional measures is contrary to Article 41 of the statute and that it aims at preserving each party's rights. He did not make any explanations to this effect and did not contest that this language aims all rights under litigation before a judge. Finally, Mr. Staker says that through its reservation on Article 8 of the Convention, Burma was not, or the court rather, could not be seized and its jurisdiction could not be invoked. Because of the fact that Myanmar did not accept Article 8 of the Convention, no party then could bring a claim before the court, whereas according to the respondent, this article does give the court jurisdiction because of the consent to Article 9. Myanmar empties Article 9 of its meaning and provides no explanation as to what its meaning could then be at this preliminary stage, where its jurisdiction must be ascertained prima facie. So at this stage, the court should not consider this argument because it is a considerable departure from the good faith with any interpretation that should be made of this treaty. Mr. President, I would now like to request that you listen to Professor Philip Sands. Thank you very much.
Je remercie le professeur d'Argent pour sa présentation.
Thank you very much to Mr. Pierre d'Argent for his oral statement. I'd like to give the floor now to Professor Sands. You have the floor.
Merci, Monsieur le Président, Madame Vice-Présidente de la Cour.
Thank you, Mr. President.
Myanmar in the first round in 6 points. And I have to say at the outset, it was hard not to be struck by Myanmar's first round arguments, a sort of back to the future of legal submissions. My first point. Mr. Staker addressed the court at length on the issue of legal interest and standing. His position, in short, was that the Gambia has no legal interest in the question of whether Myanmar is treating its citizens in accordance with the requirements of the 1948 Convention. He cited numerous cases in support of that contention, but there was one that he did not mention. As he addressed the court in dulcet Australian tones, I shut my eyes and suddenly wondered if I wasn't hearing the voice of Sir Percy Spender back in 1966, as he explained why he cast the decisive president's vote in favour of the court's conclusion. You will recall that decision, that Ethiopia and Liberia, and I quote, cannot be considered to have established any legal right or interest appertaining to them in the subject matter of the present claims, end of quote. Namely, the question of whether South Africa was treating the inhabitants of the territory of Southwest Africa in accordance with obligations incumbent upon it under international law. That judgment caused a scandal. It cast the court into a wilderness for nearly 2 decades. And this court could, I suppose, if it wishes, rule that Gambia has no legal interest in the case. But you will surely be aware that to take that approach will cast the court into an incomparably more bleak wilderness, given that the overwhelming majority of the members of the United Nations, having endorsed the reports of the UN fact-finding mission and other UN-supported activities, will be truly shocked if this court, 53 years after Southwest Africa, declines to indicate provisional measures in this case. But of course, we trust that that will not be the case. Indeed, I can direct Mr. Staker's attention to a paragraph of that dismal judgment, paragraph 66. Even Sir Percy Spender was willing to accept that if Ethiopia and Liberia had been parties to a treaty to which South Africa was also a party, which provided basic rights for the inhabitants of Southwest Africa, they would have had standing. Substantive rights, the court ruled, and I quote, may be derived from participation in an international instrument by a state which has signed and ratified or has acceded or has in some other manner become a party to it, and which in consequence and subject to any exceptions expressly indicated is entitled to enjoy rights under all the provisions of the instrument concerned, end of quote. In the Southwest Africa case, back in 1966, the 3 countries were not all parties to an international instrument like the Genocide Convention, and hence Sir Percy ruled they didn't have legal standing. By contrast, the Gambia is a party to such a treaty, and so is Myanmar. The Gambia has a legal interest, and it has legal standing. My second point, the conditions governing an order for provisional measures. Mr. Staker asserted that on the facts before you, the claim that a genocide has occurred is not plausible. Indeed, he went on, it is so manifestly lacking that the case shouldn't even be inscribed on the court's list. Reject the application in limine, he basically said. He followed the submissions of Professor Shabus, who made much of the court's jurisprudence on proving genocidal intent. Understandably, he took you to paragraph 510 of the court's merits judgment in the Croatia case. This states that, and I quote, for a pattern of conduct to be accepted as evidence of genocidal intent, it would have to be such that it could only point to the existence of such intent. That is to say, that it can only reasonably be understood as reflecting that intent. Let me be clear, the Gambia's application is based squarely on that standard. So are the conclusions of the fact-finding mission and of the Special Rapporteur and of the United States Holocaust Memorial Museum. Professor Schabas said the question you must ask yourselves at this preliminary phase is, and I quote, whether it is plausible that genocide intent is the only inference that can be drawn, end of quote. It's a reasonable question, provided, of course, that the question is posed in relation to some of the acts alleged, but not necessarily all of them. After all, it is possible for some acts to be characterized as genocidal, such as rape and killing, while others are characterized as crimes against humanity, such as the forcible displacement of human beings or their deportation. If the answer to the question posed by Professor Schabas is yes, in relation to some of the acts that are before you, then you order provisional measures. Moreover, the fact that it is also plausible that another inference could be drawn in relation to those acts does not mean that you cannot order provisional measures. Plausibility is not a zero-sum game. The plausibility of one explanation does not exclude the plausibility of another. Two explanations can be simultaneously plausible. That's a difference between the provisional measures phase and the merits phase. Professor Schabas's attempt to create a new and onerous legal standard at the provisional measures stage, one that imports the test that applies at the merits stage, has no legal basis. Indeed, neither Professor Schabas nor any of Myanmar's other counsel addressed the obligation on Myanmar to prevent genocide under Article 1 and how that interacts with the findings of genocidal intent. As this court is well aware, Myanmar is not only under an obligation not to commit genocide, but also to prevent it, a duty which arises, and I quote, at the instant that the state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed, end of quote. UN fact-finding mission reports amply demonstrate the existence of a serious risk. Can this court really conclude otherwise? That seems, frankly, a bit of a stretch, one that would be manifestly inconsistent with the obligation to prevent, an obligation that arises from the first moment of awareness. Yet Professor Schabas tells you that now, today, next week, and thereafter, you are required to apply a standard that requires a conclusive finding of solely genocidal intent simply to be able to order provisional measures. In short, the test at this stage is not whether genocidal intent is the only plausible inference to be drawn, as Professor Schabas argues. If that was the test, it would be hard to see how this court could ever order provisional measures under the Genocide Convention in relation to Article 1, since such a conclusion can hardly be reached without descending deeply into the merits. And that is something the parties agree this court cannot do at this stage. The court did not apply that test back in 1993 in the Bosnia case, although it seems that Myanmar wants you to abandon the approach it then adopted. The thrust of the convention and this court's statute is to require you to act protectively, to err on the side of caution. If it is plausible that a finding of genocide might be made on the basis of the evidence and material that is before you, then you have to order provisional measures. If it is not plausible, then you don't. Given the reports that are on the record, we don't see how this court can possibly conclude that genocidal intent is to be excluded. The agent for Myanmar told you that, and I quote, "Invoking the 1948 Genocide Convention is a matter of utmost gravity," end of quote. Indeed it is. States do not lightly invoke or allege genocide. The fact that 56 members of the OIC have decided to lend their support to this case, along with Canada and the Netherlands, and more will no doubt surely follow, speaks clearly as to the gravity of the current situation. It strengthens the case for provisional measures rather than weakens it, exactly contrary to Myanmar's argument. It is equally telling that a United States federal institution, the US Holocaust Memorial Museum, with a board of trustees that includes 4 members of the US Senate and 5 members of the US House of Representatives, has found, and I quote, "compelling evidence that the Burmese military committed ethnic cleansing, crimes against humanity, and genocide against the Rohingya," end of quote. An institution like this, a venerable institution, does not tend to make public statements that are easily characterized as implausible. Nor, might I add, does Professor Schabas, at least when he's speaking in an academic capacity rather than as counsel for Myanmar. Let us look at what he told Al Jazeera back in 2013 about the term genocide. And I quote, "We're moving into a zone where the word can be used in the case of the Rohingya. When you see measures preventing births, trying to deny the identity of the people, hoping to see that they really are, eventually, that they no longer exist, denying their history, denying the legitimacy of the right to live where they live, these are all warning signs that mean that it is not frivolous to envisage the use of the term genocide." End of quote. Now, you can watch him on video for yourself. It is publicly available on the web, and the citation is in the footnotes to this speech. Of course, everyone is allowed to change their mind. But the obvious question is, how could that which was not frivolous in 2013, before the clearance operations, before the killings, before the rapes, somehow become implausible in 2019? The path to implausibility is eased, of course, if you simply take certain categories of acts out of the equation. Myanmar has been conspicuously silent, for example, about all the sexual violence that has occurred on a wide and systematic basis. A clear reflection, we say, as do the UN bodies that have considered the matter, of genocidal intent. Yet the word rape, did not once pass the lips of the agent or of any of Myanmar's council. There was no commitment to cooperate with UN bodies, no commitment to investigate this crime on its own account, no commitment to prosecute. We heard much from Myanmar's agent about the vital importance of domestic accountability, but not a word about the women and the girls of her country, Myanmar, who have been subjected to these awful serial violations. Madam Agent, your silence said far more than your words. I turn briefly to another point made by Myanmar, the third of my points. You were taken to the recent decision of the ICC pre-trial chamber to authorize an investigation of the deportation of Rohingya from Myanmar to Bangladesh as a crime against humanity, not genocide. You see, Council suggested, how can it possibly be a genocide if the ICC hasn't said it's a genocide? Well, the explanation is rather prosaic. Myanmar is not a party to the statute of the ICC, but Bangladesh is. And the ICC's jurisdiction only extends to acts occurring on the territory of a state party. No element of the crime of genocide has been committed on the territory of a state party. No element of the crime of genocide has been committed on the territory, no element of the crime of genocide has been committed on the territory of Bangladesh. The crime of deportation, however, which is a crime against humanity, might have been committed on the territory of Bangladesh, as it is a transboundary crime. It is in no way inconsistent with the existence of a genocidal intent in respect of other acts. Indeed, the ICTY genocide cases relating to Srebrenica all also included the crime against humanity of deportation, and Professor Shabas is well aware of their coexistence. Such coexistence of distinct crimes is readily recognized in the jurisprudence of the ICTY, the ICTR, and the ICC. Myanmar suggested that the observations of various bodies, including the High Commissioner for Human Rights and the UN Human Rights Council, that there is ethnic cleansing in Rakhine somehow precludes the plausibility of a simultaneous finding of genocide. That suggestion is wrong in fact and in law. As this court made clear in its Bosnia versus Serbia judgment, it is clear that acts of ethnic cleansing may occur in parallel to acts prohibited by Article 2 of the Convention and may be significant as indicative of the presence of a specific intent, dolus specialis, inspiring those acts. In 2015, the court reaffirmed in its Croatia versus Serbia judgment that, and I quote, acts of ethnic cleansing can indeed be elements in the implementation of a genocidal plan, end of quote. My fourth point, Myanmar made a number of claims about the 1993 orders in the Bosnia case, presumably in response to our argument that those orders are instructive and offer an appropriate starting point for what the court should do in this case. It seems that Myanmar doesn't like the 1993 orders very much. Mr. Staker told you that they were merely a 26-year-old precedent and that they predate the court's important ruling on binding provisional measures in La Grande. But he seems to have missed paragraph 452 of your 2007 Bosnia judgment, where the court stated explicitly that the fact that the 1993 orders predated La Grande, and I quote, does not affect the binding nature of those orders, end of quote, which, I quote, created legal obligations which both parties were required to satisfy, end of quote. Mr. Staker also submitted that the 1993 orders were, in effect, useless, which is my fifth point. Provisional measures in such terms serve no useful purpose, he told you. We are grateful to him for reinforcing the point we made on Tuesday when I reminded you that the 1993 orders failed to prevent the genocide at Srebrenica 2 years later. Provisional measures worded in such broad terms, Mr. Staker explained, make it impossible to know what the precise conduct might be within provisional measures. We agree. The court must go further on the first and second provisional measures and specify with as much precision as possible and on the basis of what has already occurred the kind of acts that Myanmar must refrain from and prevent. Indeed, to the list we have already provided to you, we would have no objection if you added the acts identified by Professor Schabas in his 2013 interview, like the prevention of births, the right to live where you live, and the denial of the identity of the Rohingya people. On the last point, we noted that the agent said that, and I quote, all children born in Rakhine, regardless of religious background, are issued with birth certificates, end quote. Notwithstanding the UN fact-finding mission's conclusion that this has not been the case, the agent's comment seems to imply, at the very least, a recognition that the Rohingya are human beings, which seems like a concession. But she did not recognize their right to citizenship. And, as you will have noted, and Mr. Reichler reminded you, did not feel able to mention the word Rohingya. We noted, incidentally, that the agent, like her counsel, passed in total silence over the genocide at Srebrenica, one recognized by this court. Perhaps this was because the numbers killed, 8,000, are, in the view of Myanmar, simply too small to merit recognition. After all, as Professor Schabas put it in the case of the Rohingya, and I quote, 10,000 deaths out of a population of well over 1 million might suggest something other than an intent to physically destroy the group, end of quote. But genocide is not just a numbers game, Mr. President. And the Convention makes clear that the intention to destroy a group in part is sufficient. You have evidence before you that entire Rohingya villages have been destroyed, and most, if not all, of the inhabitants have been killed. There is ample authority in the jurisprudence on genocide to support the view that such destruction of an entire community in a limited geographic area on grounds of ethnicity or religion or race, and even where it is not the whole protected group, can properly be characterized as an act of genocide. My sixth submission concerns the other provisional measures we've requested, on which Myanmar had very little to say. On the third measure, they wondered what evidence related to the events described in the application might mean. With respect, Myanmar is assisted by a team of experienced international counsel who can advise them on exactly what this means. It starts with the preservation of mass graves, the preservation of bodies of victims, and the preservation of destroyed villages. And it continues to all the other evidence which presumably is of the kind Myanmar now says it will be gathering for the investigations which they have told the court they are committed to undertaking. The fourth provisional measure, not aggravating or extending the dispute, is standard in the practice of this court. Again, if Myanmar is in doubt, it can obtain advice from its experienced counsel. The fifth provisional measure would impose a reporting requirement, and as Mr. Staker well knows, it is not intended to create some sort of human rights monitoring machinery. It simply requires the parties to inform the court as to the steps they are taking to give effect to the provisional measures orders indicated by the court. This is routine, for example, in matters relating to the law of the sea, which, while of very great importance, cannot be said to be as grave as the issues that arise in this case. If reporting is good enough for the law of the sea, it's certainly good enough for this case. As to the sixth provisional measure, we say it's proper and appropriate for a number of compelling reasons. First, it is intrinsically linked to the obligation under Article 1 of the Genocide Convention to prevent and punish genocide. Effective investigation and the preservation of evidence are fundamental to preventing impunity for genocide and thus complying with the Article 1 obligation. Yet the consistent picture before the court is that Myanmar is refusing to cooperate with or provide access to investigative bodies to collect evidence, thereby creating a material impediment to the eventual punishment of genocide, and that it is itself destroying evidence, including by bulldozing destroyed Rohingya villages. Since Myanmar has proved itself to be unwilling to investigate what has occurred in any real sense, it is only by ordering it to cooperate with independent UN investigators, currently in the form of the Independent Investigative Mechanism, that this court might be able to assure itself that the Gambia's right to have other parties to the Convention comply with their Article 1 obligation will be protected pending the resolution of this case. Second, the sixth provisional measure is consistent with the jurisprudence of the court. It builds on the order that was made, for example, in the frontier dispute case. The parties should refrain from any act likely to impede the gathering of evidence material to the present case. Myanmar's persistent refusal to cooperate with UN fact-finding mission has already impeded the gathering of evidence material to the present case. And it's only by indicating the requested provisional measures that further impediment can be avoided. The requested measure is not, as I've said, novel. It's the same in substance as the order made in the frontier dispute case, adapted to the specific circumstances pertaining to this case. Further, it is directly linked to the Article 41 requirement of preserving the respective rights of the parties. It is necessary to preserve the integrity of these proceedings and the Gambia's right to have its claim fairly adjudicated, because this claim will in due course depend on the evidence that can be collected. Myanmar's non-cooperation with international investigative bodies threatens that right, and a provisional measure in the form requested is necessary in order to protect it. Mr. President, members of the Court, I will conclude. As I mentioned in my first round statement, genocide is not a single act. From its very genesis, it has been recognized to be a continuum. That was the only point I made in invoking the spirit of Dr. Lemkin. And it is comprised of different actions, which individually and together, and over stages and time, amount to this most heinous crime. With genocide, one thing always leads to another. That was the point of invoking the spirit of Primo Levi. The situation the court is confronted with today is a delicate one. Unlike in the Bosnia case, there is no international criminal tribunal with special responsibility for the crimes committed in this case. Today, the hopes of the Gambia and of the Rohingya people, some of whom are in the Great Hall today, rest entirely with you to exercise the power vested in you by Article 41 of the statute, and to grant specific, protective, provisional measures to interrupt and prevent the continuum of genocide, to break the chain that has already occurred and is continuing to occur today in Rakhine. Myanmar urges you to take a different path. Peace and harmony is best assured by doing nothing, the agent told you yesterday. Forget about the 1993 orders, Council said yesterday. They're useless. Go back to the glory days of 1966 and the Southwest Africa judgment. Council, in effect, pleaded, but not its paragraph 66. and forget about the Genocide Convention of 1948. Just give Myanmar the space and the freedom to act, unfettered by the unfortunate distraction that is international law. Perhaps some of you might be tempted to do that. But we trust that the court will exercise its judicial function, that it will apply the law, that it will give effect to the requirements that the drafters of the 1948 Convention entrusted upon you, and that you will not abdicate your judicial functions and responsibilities. Mr. President, Madam Vice President, members of the court, the eyes of the world, of individuals and of groups, of countries and of United Nations bodies are upon this court. That concludes my submissions. I'd like to express my thanks to all my colleagues for their assistance, in particular Ms. Jessica Jones. I thank you for your kind and patient attention and invite you to ask the agent of the Gambia to the bar.
I thank Professor Sands, and I shall now give the floor to the agent of the Gambia, His Excellency Mr. Abubakar Mari Tambadou. You have the floor, sir.
Mr. President, honorable judges, it is an honor to address you once again as the agent of the Republic of the Gambia. As you heard on Tuesday and this morning, the situation of the Rohingya in Myanmar is dire. The evidence from various United Nations bodies and independent human rights organizations clearly establishes the urgent and imminent risk of the recurrence of genocide that they face. The lives of these human beings are at risk. The Gambia may not be a neighboring state, but the Gambia has a keen and special interest in seeing that no group of people, including the Rohingya, suffer genocide. As a state party to the Genocide Convention, the Gambia has come to this court to protect its rights under the Convention, to ensure that the erga omnes partes obligations undertaken by Myanmar under the Convention are fulfilled. Those obligations not to commit genocide and to prevent and punish genocide are owed to the Gambia and indeed to all other state parties to the Convention. Mr. President, honorable judges, the Gambia has been open about its dispute with Myanmar. We openly raised this dispute at successive sessions of the United Nations General Assembly. We have openly welcomed support for this effort from other states, including member states of the Organization of Islamic Cooperation. Indeed, it was from beginning to end the Gambia's initiative to table resolutions and form a committee and seek the broader support of the other 56 member states of the Organization of Islamic Cooperation. The Gambia is proud to have the diplomatic and political support of the other 56 member states of the OIC and of other supportive states like Canada and the Netherlands, as the Gambia, in its sovereign capacity, pursues this case against Myanmar. It was the Gambia alone that sent the note verbal to Myanmar to clearly spell out the nature of this dispute and put Myanmar on notice. And it was the Gambia alone that has filed the application and request for provisional measures that is now before the court. Mr. President, honorable judges, the Gambia's request for provisional measures falls squarely within the Genocide Convention. We have shown that the rights of the Gambia that we are seeking to protect are plausibly connected to the measures requested. And we have amply demonstrated urgency and risk of irreparable harm. The Gambia urges this court, as the guardians of our moral and legal compass under the Convention, to indicate the requested provisional measures. Mr. President, I shall now read out the Gambia's final submissions. Pursuant to Article 41 of the Statute of the Court, the Gambia, as a state party to the Genocide Convention, respectfully requests the court, as a matter of extreme urgency, to indicate the following provisional measures, which are directly linked to the rights that form the subject matter of this dispute, pending its determination of this case on the merits. A. Myanmar shall immediately, in pursuance of its undertaking in the Convention on the Prevention and Punishment of the Crime of Genocide of 9 December 1948, take all measures within its power to prevent all acts that amount or contribute to the crime of genocide, including taking all measures within its power to prevent the following acts from being committed against any member of the Rohingya group: extrajudicial killings or physical abuse, rape or other forms of sexual violence, burning of homes or villages, destruction of lands and livestock, deprivation of food and other necessities of life, or any other deliberate infliction of conditions of life calculated to bring about the physical destruction of the Rohingya group in whole or in part. B. Myanmar shall, in particular, ensure that any military, paramilitary, or irregular armed units which may be directed or supported by it, as well as any organizations and persons which may be subject to its control, direction, or influence, do not commit any act of genocide, of conspiracy to commit genocide, or direct and public incitement to commit genocide, or indeed of complicity in genocide against the Rohingya group, including extrajudicial killings or physical abuse, rape or other forms of sexual violence, burning of homes or villages, destruction of lands and livestock, deprivation of food and other necessities of life, or any other deliberate infliction of conditions of life calculated to bring about the physical destruction of the Rohingya group in whole or in part. C. Myanmar shall not destroy or render inaccessible any evidence related to the events described in the application, including or without limitation by destroying or rendering inaccessible the remains of any member of the Rohingya group who is a victim of alleged genocidal acts, or altering the physical locations where such acts are alleged to have occurred in such a manner as to render the evidence of such acts, if any, inaccessible. D. Myanmar and the Gambia shall not take any action and shall assure that no action is taken which may aggravate or extend the existing dispute that is the subject of this application or render it more difficult of resolution. E. Myanmar and the Gambia shall each provide a report to the court on all measures taken to give effect to this order for provisional measures no later than 4 months from its issuance. And F. Myanmar shall grant access to and cooperate with all United Nations fact-finding bodies that are engaged in investigating alleged genocidal acts against the Rohingya, including the conditions to which the Rohingya are subjected. Mr. President, honorable judges, this concludes the Gambia's second round of observations. I wish to take this opportunity to thank you once again for your kind attention. I would also like to take the opportunity to thank all members of the registry, the court staff and security, and the interpreters for their dedicated work throughout the hearings. I thank you. And with your permission, Mr. President, I would like to take my seat.
You have my permission. I thank the agent of the Gambia. The court takes note of the provisional measures requested by the Gambia that you have just read out on behalf of your government. The court will meet again this afternoon at 4:30 p.m. to hear the second round of oral observations of Myanmar. The sitting is adjourned.
Thank you very much and welcome back, viewers, as you were following proceedings there at The Hague, where the Gambia just ended its second round observations on the court proceedings against Myanmar on the genocide acts that it has filed against Myanmar at The Hague. And of course, that was the Gambia's Justice Minister and Attorney General Abubakar Tambedu speaking there. And of course, he concludes the Gambia's second round observation there with quite a very strong message and on behalf of the Gambian government. Of course, before him we had 2 other lawyers that were also that have also, of course, presented or defended Gambia's position in this case. And yeah, coming back to the studio and of course to briefly digest on what we heard from the Gambia's team to The Hague with regards to its petition and its position with regards to the mission they had against Myanmar. Well, Ibrahim, again, finally Gambia have concluded its second round observations. What's your own impression or feeling with regards to what you heard from the 3 speakers?
Yeah, exactly. It was a very busy second round, and Gambia had about 4 of the council teams to do additional submissions. And if you look at it, I would like to pick up from the Gambia's agent, the last point where he made recommendation that none of the parties' actions should be in such a way that it will aggravate the situation of the victim in Rohingya already. So whatever is to be done is in the interest of humanity. So this is a very powerful, call, which one need to observe now. And looking at also the Paul Reichler's presentation, for him, his focus is the urgency of provisional measures. So what should be done as soon as possible to prevent the discontinuation of genocide in Myanmar? And he make a long list of situational problems, where he point out the constitution of Myanmar itself, creates a discriminatory, approach towards these minority people in Myanmar. So these are, loud calls that the court will have to look into and then consider, taking action upon. Again, it is just one way again, because this is a second round. So he who alleges must prove, and that is the situation in which Gambia is right now. Gambia is taking up the case, and then they have to prove that everything they said is valid and plausible. Now, who knows? Let's see what Myanmar will come up with.
Well, listening to, of course, after we all heard what Myanmar's team put on the table before the judges yesterday. Listening to the Gambia's team, including Ba, do you think they have at least tried to do justice to some of the denials that the Myanmar team were trying to say or to refute on what earlier on Gambia have said with regards to the genocide and the killing, the raping of women and all that happened?
This is exactly the point of Reichler. He said, Myanmar might have had right to prevent terrorism or to conduct anti-terrorism activism, but does it involve killing innocent people, raping on women, trying to destroy villages? Are these definitely justifiable actions in the name of counter-terrorism, for example? So these are, evidence that the Gambia side is bringing up to prove that, indeed genocide occurred, and the government and authorities of Myanmar were complacent of it. So also, if you analyze what Ba is saying, when it comes to the, connectivity with OIC, the Gambia's agent, repeats loud and clear that it was their pride, it was their desire, and openly they have done that to pass resolution. Independent state and member of the OIC to request, solicit support from the OIC. And then 56 other states are backing Gambia on this, because it is a cause for humanity, protecting one another's brother. So that is the position that Ba is trying to portray before the world, that Gambia is not regretting, does not have any cause to regret what it does, and it will continue to seek support from anyone who is standing for the cause of humanity.
Interesting. Julde, of course, the president have said that the court has heard the Gambia's case, and of course, message as well from the government read out there by the justice minister. Upon hearing from the entire team, four of them spoke today, including Ba himself. What is your own reading, of their arguments today with regards to what the other team have put forward yesterday?
This is more like a refutal of what the Defense Council team was saying. That is yesterday. They are coming on board to clear the air. And one of the things that the prosecution witness or the Gambia is actually saying is that, based on all the submissions that they made, the Rohingya, Madam Sue did not actually include sexual violence that actually occurred, in Myanmar, including children and women. And this thing is actually something that was obvious to anybody who is actually watching these things. So she said that she did not actually mention it in his words, Paul's word, because it is undeniable and unspeakable. That is why, it was not mentioned, that the violence against women and children. And another thing that, they mentioned is the discriminatory laws in Myanmar against other people, that they can you know, they are only allowed to be given birth certificates, you know, but they don't have the rights, you know, for citizenships. All these things is in contradiction to the convention. And another issue that they made a stand is that, you know, the genocide that Madam Sue said yesterday, that some of the military men who actually kill these innocent victims are actually prosecuted. But he is actually saying that, you know, clean innocent people, and then you prosecute those people within 7 months. Those people are released. You know, is actually putting a big question mark.
They have some pictures where you can see those
exactly
10 people were tied behind, and of course, you know, and they were eventually killed. And those were, you know, very, very, you know, touching scenes to say. But then, like you said, you know, after all, it's also going to be interesting to hear from the Rohingya, the Myanmar's team. What are they going to come with?
Yeah, and even Paul did also mention that according to the UN, you know, fact-finding mission, is that the government of Myanmar, they are actually capable, but they are unwilling to change the situation of the Rakhine people. So these things are all things that they brought in, and it's really complicated right now. Gambia has really defended its own position, and they made it very clear that, you know, from the initial stage they were against this thing, that it was not a secret to the Myanmar that, you know, Gambia is actually eventually, or it's against what these people are doing actually to innocent victims.
All right, let's cross back to The Hague and talk to Brad Adams, who Gambia's team, as you listen to the arguments right now. Hello. Well, apparently it looks like we're having some technical issues to hear from Adam. Yes, press. You want to say something?
When you look at the case as of 10 of December, that the Gambia authorities also, or the agents for the Gambia brought in there, you realize that still now, you know, army generals of Myanmar are still culpable in the view of United States. 10 of December, on the Human Rights Day this year, the U.S. government, you know, imposed sanctions on some of them and warned that such human rights violations, abuses, should stop. So I think this is coming at a very precedented time where, you know, Gambia is just putting up a case, and then it, you know, countries like the United States is able to, you know, come up out publicly to condemn or to sanction military men in Myanmar.
I hear you, yes.
You know, to be
you hear me?
honest, is also a plus to the case. So all in all is, you know, the case of Gambia is, what has Myanmar authorities been doing? What have they been doing? If they had got some, you know, local remedy in, I mean, satisfying the situation, it would have not reached here maybe. But in the view of OIC, for example, it is a religious group, and that, you know, recognize the right or the equality of humanity, for example. So this is a point where Gambia is relying heavily on to see how best to, you know, come about or bring about justice.
All right, it looks like we are good to go and back to The Hague to hear from Brad Adams, who is before you know, the hearing started. Well, Adams, if you can hear me now, well, after Gambia's ends its second round observations today, would you call that one a strong message again from the Gambia?
Justice system would be able to
We've also seen some Gambian evidence from the Gambian side is based on the United Nations, fact-finding mission, and now the getting into journalistic articles and opinions. So where else do you think is possible sources of, information that justifies genocide?
Is that a question for me?
Yes,
Yes.
I suppose you would have something to say on this, because we've seen the as of
There are very many sources of information on this. The fact-finding mission is very comprehensive, but they rely on the Rights Watch and the international Rohingya groups, media groups, government sources, satellite imagery. When we published satellite imagery that showed villages that were perfectly intact one day and then burned to the ground the next in September of 2017. There's no lack of documentation here. There is simply a lack of admission and acknowledgement by the Myanmar authorities. I don't think the court is going to have any trouble finding that the facts submitted are valid. I think that the only question is whether or not they will find genocidal intent, and I think the evidence of that is extremely strong, and the Myanmar government has done nothing to undermine that claim.
Yes. All right. Now that, of course, like you said, it looks like, of course, we are hearing some interesting argument from both sides, though. With Gambia's one looks very strong, as you said. Myanmar is also coming next with another observation, second round observation or argument, whatever. What are we to expect? Do you think they would come up with something tangible, maybe to put forward or to convince to the judges that all that Gambia is putting forward is something that they can deny? What should be the expectations?
I think we're going to hear a lot of legalese, a lot of very hard to understand legal arguments about prior ICJ court cases, because I think after this morning, they will be too embarrassed to try to argue the facts. And Aung San Suu Kyi looked shocked, and she looked like she was wishing she could be anywhere in the world except in that courtroom this morning. They described rape. They pointed out that the Myanmar government never mentioned rape yesterday. And they pointed out that she refused to use the word Rohingya, so she's trying to deny their existence. I don't think they're going to try to argue the facts. I think they're going to try to argue that the prior court cases at the ICJ would suggest that the court should not find genocidal intent and therefore issue provisional measures. But I think it's a very weak argument.
Okay.
This is really about the strongest case that could be presented under the Genocide Convention for provisional measures, since it's very obvious that the Rohingya remain at grave risk of another round of violence at any time.
All right. Well, just maybe a quick one. Finally, outside the courts, after yesterday's hearings, what are people saying? Actually, because we have people who are, of course, supporting the Gambia's case, and others probably also, supporting the Myanmar's team there in the Hague. What are the views? What are people talking about, if there's any, or if you managed to talk to anyone since yesterday to now?
Yeah, I spoke to people on both sides. There was a large number of Rohingya and there was a large number of supporters of Aung San Suu Kyi. They were kept separated by the police. There was no violence. And it was actually very, fairly calm. The Aung San Suu Kyi supporters were flown in by the government. It's a little bit hard to know how sincere their beliefs were, but I felt personally sad because for years, Human Rights Watch and many others fought for Aung San Suu Kyi's release and for the National League for Democracy, her party, to be allowed to participate in politics in Myanmar. And their claim, backed by our investigations, was that the Burmese military was a highly abusive force that had committed crimes against humanity and war crimes, amongst other serious crimes. And now those very same people were standing in front of the ICJ supporting the Myanmar government. And it just shows that many people simply follow the leader instead of following their conscience. And those people who said they were for democracy and human rights when Suu Kyi was in prison apparently were just for Suu Kyi and not for democracy and human rights. For the Rohingya, it was extremely upsetting to watch Aung San Suu Kyi's presentation yesterday. I think they all knew that she would say what she said, that she would deny genocide, that she wouldn't use the word Rohingya, but still, it was very disappointing for them to see the person that a lot of them used to believe in come to court and basically deny their existence.
So, quickly looking at the submission and counter-submission, do you think this is a busy work for the Court of Justice?
Well, I was talking to some of the lawyers involved here in The Hague, and they expect a decision in early January, only delayed because of the holidays that are coming up. Some of them actually hope that they might get a decision as early as late next week. I don't think they believe it's a very difficult case. There are 17 judges. Most of them would act independently. Some of them probably are put on the court by their governments. They're not expecting a unanimous decision because the ICJ, the judges on the ICJ sometimes try to represent certain interests instead of just looking at the merits of the case. But I think they expect a large majority in favor of the Gambia.
Brad Adams, Executive Director of Human Rights Watch Asia Division. Thank you very much for your time. Again, we'll hope to link you up again, probably before or after the Myanmar's team present their case. Thank you very much for your time.
Sure. Thank you very much. I'm really glad you're covering it so closely.
Thank you. Pleasure. Again, Press, just quickly. Well, it looks like we are up for a very interesting moment again. He have said it. Gambia maintains its strong position and strong message, and maybe trying to, of course, further, put a strong foot on what it has earlier on put before the court. And it looks like, despite what Myanmar team or the Myanmar's team have said yesterday, there's still something to listen or to argue for in Gambia's case, especially listening to what Brad has said. So, what's gonna happen, do you think, again after we hear from the other side? Of course, there is
actually, and this is the second round. What just happened is a re-emphasis on the position of Gambia. Gambia had put up a case, and there is in no way that it will be there without defending it. So what is eminent is Gambia is insisting that genocide happened. Genocide occurred under the watch of the authorities of Myanmar. Nothing was done tangible to prevent the reoccurrence of the genocide. This is one of the primary points of Gambia relying on. The next thing is the agent for Myanmar tried to say that who is Gambia to come up with such a case against them. Well, but in the reply of Batambedu, who is agent for the Gambia, you could realize that we may not be the neighbors to Myanmar, according to his words. But in terms of humanity, we share the same thing. So in terms of jurisdiction, he is trying to prove to the court that, Gambia has the right as a member state of the UN, equal to the membership of Myanmar to bring any case that is of human rights violation. So Gambia is pushing on this. In terms of urgency, the matter of urgency, that no one has denied so far that people have not died. Mass exodus of people had not happened. Women are not raped. Actually, villages are not destroyed. What has happened? Who has been held accountable for this? So for this, I think the Gambian team is feeling like, something should be done, and now.
Well, Brad said the Myanmar's leader, Aung San Suu Kyi, looks very shocked, especially after listening to Gambia's legal team today. How do you think she would look like coming back for the second time, knowing that she is fighting something that's very difficult to fight, killing of people, raping of women and girls, and other things that happen, and which the Gambia's team have presented and provided some evidence on pictures. Do you think they would, she would be that strong and as a woman, as she's known for? Because some years ago she was seen as an icon, woman globally. But today it's a different one. And how do you think she would look like when she comes back before the judges later on?
This thing is very, very complicated, but looking at her history and her accomplishments in terms of human rights, particularly in the area of women, I think it's going to be a tough moment for her, because and sadly, yesterday in her deliberation she didn't even mention the sexual violence that is happening there against women and children. And this is a call for concern for someone like her. Like you said, so many people are looking up to her, because she's a global icon.
Absolutely.
So it's going to be very, very difficult to actually defend her stance in terms when it comes to not only the killings but the sexual violence against women and this thing. And even this on the Gambia side, he did mention that because her silence are more than her words. Like what she said, what she's keeping is actually more than what she has said, because actually we believe that what is kept is more than what is said, because it's involved these vulnerable groups, these women, these children, being killed, being raped, and all those things. It's very sad, and I am of the belief that she is going to find it very, very difficult to defend. And interestingly, she didn't deny that there was genocide actually, which
Absolutely.
is something that is in the plate right now. It wasn't denied that there was no genocide, the atrocities committed and all that, and also the steps that Myanmar's government have taken in making sure that it has, it will never repeat itself again, because even the position paper, the position of the Gambia, the submission of the Gambia to the court has urged, the court, the government of Myanmar to ensure that there is no repetition of what has occurred here. The stance, and also the demands. Also, part of the demands is making sure that they give, access to the UN fact-finding mission or investigators, to have access to these things and make sure that they have first-hand information, and also making sure that both the Gambia and the Myanmar's government do not do anything that will jeopardize, the peace, or that will fuse conflict between in Myanmar and the people of Rohingya, which I think is very, very important. The stance of the government, they did not only focus on Myanmar, but also what the responsibility of the Gambia in making sure that this did not, worsen the situation, which I think is very, very important. And evidence is important because our Justice Minister made a strong point, because yesterday we heard from Aung San Suu Kyi that this thing, Myanmar's government, actually most of the evidence from the Gambia side is actually based on documents which are not even official. It's backing up from press releases, from the UN fact-finding missions, and all these things, which I think is very, very important. So the court actually needs first-hand information or evidence to actually ascertain the case, which I think is very, very important.
All right, Julden Jai, thank you so very much. Ibrahima, thank you very much. Press, of course, for the excellent analysis, and that's why it is. And of course, viewers, once again, thank you very much. Oh, and also we should say a very big thank you to Brad Adams, who is, at the Hague following the proceedings, and also giving us some great contributions on what is going on right now at the Hague. And we just witnesses the second round observation of the Gambia's team to the Hague, led by Attorney General Justice Minister Abubakar Batambedu. And of course, later on, in the day. We'll be back again to hear what the Myanmar's team is going to come up with, and then of course we will then see what's going to happen next. But for now, we want to thank you very much for the pleasure of your company, and keep watching EYEAFRICA TV. Some interesting programs coming next, but join us again later when we, of course, together we will follow the proceedings at the Hague as it has been happening since yesterday. So now, thank you very much, and see you later.